judge to try, etc., etc. Then my lord 4.3 is mentioned. Section 230, 223 is mentioned. And my lord, last line of that para, applying section 3 and 4 and 220, 223 must be held that the appellant co-accused may be tried by the special judge in the same trial. This is because the co-accused of co-accused appellant have also been charged with offences specified in section 3 must be tried special judge who in view of 4.3 read with 220 may also try them of the charge under book. All the three accused, including the appellant, have been charged under 120, 420. The special judge jurisdiction to try the co-accused under 420, then my lord, obviously this fellow will also be tried. So there is no doubt now that my lord, persons charged purely with my lord non-PC will also be tried, and that other judgment is on the proposition that if my lord one fails, he will still retain, or it will be my lord a ping pong. He cannot be my lord. That's not the object of the law. But this is not to say, my lord, that I am conceding his yet. I am showing the legal position. Now we go, my lord, straight to the question. Now in this case, there are 36 other accused before him. He is A37. My lords will know. Who are public servants. So, my lord, for some the allegation may be prior, for some the allegation may be later. All this will remain in a jumble if, my lord, this back and forth has to be done. So it cannot be done.
They all are public servants?
So, lot of them. Not all, my lord, lot of them. Lot of them.
A single 17A sanction.
No. Now, my lord, now, my lord, I will just address your lordship briefly on 17A. My lord, kindly have my lord 17A for a second. And please note, my lord, before I read, this act was, my lord, amended wholesale in the year 2018. My lords will note that, my lord, your lordships are aware. Section 8, 9, 10, 11, 13, everything is amended. And for example, my lord, not necessary to read it, but for example, if your lordship will see, my lord, see, my lord, for example, 8, my lord. I'm not going to read it, I just want to show you the wholesale amendments. C7, my lord. C8, my lord. In fact, my lord, if your lordship sees from 6, from section 7, section 8, all these your lordship will find an asterisk on the top of the section. All the asterisks at the bottom will show you that the amendment, my lord, is of 26th of July 18. So there is a wholesale amendment of the act. And 17A is a new insertion and not an amendment which came with the package. I'm calling it the new package. The new package is a wholesale amendment with, my lord, a new section. But, my lord, because of Article 21, the old package, using the phrase old package, the old package prior to 18 of the offences, my lord, under 8, 9, 10, because the old package is there, it's not, my lord, gone. The old package will apply to the offences covered by the old package. Putting it very simply, my lord. Old package and offences relating to the old package will be governed by that law, otherwise there will be a violation of Article 21. The new package, in which 17A has not born, the new package will deal with the new offences. So, my lord, the old package, which is prior to 18, I'm paraphrasing now, the old package prior to 18 of the PC Act, my lord, will deal with offences which have occurred when the old package was operating. So, my lord, offences of 2015, 16, 17 or early 18 will be governed by the old package, which is, my lord, prior to 2018. If there are, my lord, offences which occur after the new package comes in, they will be governed by the new package. And the new package means, my lord, the amended sections and what is born along with the amended sections, which is 17. It's as simple as that. So, therefore, my lord, in the facts of this case, the offences relate to a period much prior to 18, number one. Therefore, it will be governed by the old package and not below by the new package or 17A which came in with the new package. That's the first thing. The second thing, beloved, if your lordship now sees, beloved, 17A, and beloved, on this question, whether offences prior to 17A or of the old package and will not be governed by 17A is also no longer res integra. I will show you judgments, beloved.
Section 13 also was amended.
Everything is amended, beloved. Wholesale amendment. He is charged under the old section. Let's be very clear, beloved. He can't be charged under the new section because the law is when you commit an offence, on that day the law prevailing.
Have you specified anywhere?
Sorry.
Have you specified anywhere that they have been charged under the old offence?
Yes, yes. There's no dispute of that, but please take it. For example, beloved.
Rohadgi,
Yes.
suppose he is charged with substantive offences
Sorry. Yes.
on the date of the occurrence.
Yes. The law applicable on the date of occurrence is the law which is applicable.
Yes, but subsequently a law comes
Is it please?
by which a greater degree of protection in prosecution
Yeah.
is afforded to an accused.
Will not apply. Answer will be that it won't apply.
No,
Because
if he is made accused also later on.
the question is this, beloved. The law is triggered which is applicable on the date of the offence, no matter, because there is no limitation, no matter that the FIR is later. The question is, let's take an example. If I hit somebody today, I may be charged with 323.
Yes.
Later on, Lord, after 5 years, 323 can be removed and it becomes, Lord, 326. That won't apply. The action which I took, which resulted in the offence today, will be linked to the law applicable today. Simple. It cannot be, Lord, whether it is beneficial or otherwise. It could be both ways, Lord. It will be beneficial or worse. So it will apply on that day. And I will show you judgments that this question, Lord, is no longer res integra. I'll show you that. But before that, I am showing you, Lord, 17A on the face of it has come with the new package. Cannot, Lord, apply, Lord, by parachuting itself into the old package. It cannot parachute. It has been born of a new package. Unless the law clearly said that we will still apply 17A, notwithstanding that the offence may be earlier. Lord, the law can clarify. I am not saying, Lord, Parliament doesn't have power. It may do it. But it cannot. It has not done so. Now see, Lord, the second question which arises in 17. I'll show you this. But please take it, Lord. He is charged in the pre-2018 offences. Please charge. Please note that. FIR says so. There's no dispute of that. And your Lordship may take it, Lord, in this wholesale amendment, some sub-clauses of 13 have been omitted. In 2018. That does not mean, Lord, that a person who's charged with those omitted sections in 2016 will walk away free. The omission is today. Let us say omission is today, Milad, and you commit an offence yesterday. You will be tried there, unless the omission says not only omitted today or repealed today, but all pending will also go. Milad, Parliament can do all that, but that is not, Milad, the normal proposition or normal position.
Then that mollifying effect principle.
That's right.
will come.
That's right, Milad. Can always be done. Sometimes the law provides, Milad, proceedings will lapse. Not go on. Like, Milad, the new Land Acquisition Act. Proceedings will lapse under the old act if possession is not taken, etc., etc. Now, Milad, see some other questions which will arise in 17A, which I submit cannot be answered, Milad, by a court under 482. Kindly turn to that. So I am giving you various, Milad, facets of
ఇలాంటి మరిన్ని
17A.
వ్యూస్ ని
One when it applies
ఇలాంటి
earlier
మరిన్ని వీడియోస్ ని మీకు
cannot
అందిస్తా
apply to
ఉంటాను
this case. That is one facet. on
అలాగే
which I
మనకి
will give a
భోజనం తర్వాత
judgment.
కూడా ఈ
But before
వాదన
I do
జరిగే
that,
అవకాశం
Milad,
ఉంది
see the other facets of 17. Correct. Milord, is very important before I go further. Milord, he is charged under 13(1) C and D.
That they have been omitted.
My lord, My lord, kindly note that. He is charged under 13(1)(c) and D, which have been omitted. Not his case, my lord, that the prosecution fails on this ground. Now kindly turn, my lord, to 17A. One facet is what I have indicated to your lordship, my lord, how it will apply, cannot apply to the old chapter. Now see further, my lord. The second thing which I am now proposing, my lord, my submission is that this fact cannot be decided in 482, and that is this: no police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant, he was a public servant, where the alleged offence is relatable to any recommendation made or decision taken by the public servant in discharge of official functions. This part is incapable of being decided unless, my lord, it's an admitted position. Cannot be decided, my lord, in a 482. Whether, my lord, it is relatable to a recommendation, firstly, whether it is relatable to a decision, secondly, whether it is relatable to discharge of official function, thirdly. None of these questions, my lord, is capable of being decided in 482 unless it's a case, my lord, of an admitted position. I am saying, my lord, that the decisions which he took, the actions which he took, have resulted, my lord, in immense corruption and loss to the state, and therefore are not relatable. The other side will argue that they are relatable. No doubt, my lord, that they are relatable. So, just as an example, my lord, I don't want to go further. It is settled law that this cannot be decided in 482. Now the importance is, what is the basic fact?
At what stage it is required to be decided?
Sorry?
At what stage it is required to be decided?
At the trial. We are very grateful for their query. It is answered by this.
What is the sense of taking
So that's what I'm correct.
even inquiry?
Correct, but it cannot because of the words of the section.
What material would be there with the sanctioning authority when such sanction is granted under 17A?
So my lord, under 17A,
Inquiry is not permissible.
no, preliminary inquiry is permissible. See, suppose you have a preliminary inquiry. You may have a preliminary inquiry. The question is, my lord,
No,
these words.
doubt on that because it's any inquiry or inquiry.
Yes,
There is nothing like preliminary inquiry or final. Inquiry is inquiry under CRP.
that's right. That's right. That's right, my lord. Have a look at the words again. Have a look at the words.
E and I. RPC only gives I inquiry.
My lord, CRPC uses only I wala inquiry. It doesn't use the word E. But anyway, my lord, have a look at this. No police officer shall conduct any inquiry or investigation into an offence alleged to have been committed by a public servant where the alleged offence is relatable to this without prior approval in the case of so and so. So, my lord, the bar is that nothing will be done without approval if it is relatable to, my lord, a recommendation decision in discharge of official function. I am respectfully submitting, my lord, that a case of corruption, misappropriation of funds, ex facie, not prima facie, can never be a part of, my lord, a recommendation or a decision in discharge of functions, and I will show a judgment of that.
What is the difference between approval and sanction? Because under 19, one has to.
Now come, yes, C19, very
Here it is approval.
correct. Now C19, you are seeing right. We should see both. C19. There are three sections actually: 17A, 19, and 197. You are C19. Now, why 19, my lord, remains and why 17A came? No court shall take cognizance. So it was a bar, complete bar. Cognizance of an offence straight, not, my lord, whether on recommendation or doing in discharge of duty, nothing. 3, no court shall take cognizance of an offence punishable so and so, straight away. Absolute bar. Now, this, my lord, is changed in respect of the second chapter or the second package, because it was felt, my lord, that honest officers were unwilling to take even, my lord, an honest decision, because they feared, my lord, this will happen, that will happen. Take for example, my lord, give you an example. Delhi requires, my lord, a ring road. You have 2 ring roads. So, my lord, the authority, my lord, sanctions that you should have a ring road, right? And you have a tender or grant it to somebody, etc. If he does it, my lord, honestly, that you have a ring road, that's a decision he has taken in the interest of the public. But if it is found that for the decision which may be in the interest of the public to have a ring road, he says, give this contract to Mr. A without a tender. In this case, this is granted, my lord, without tender. I'll show that to you, lord. Without tender, it is granted, and hundreds of crores are given away. That part, my lord, is not, my lord, protected. My lord, this is the Prevention of Corruption Act. This is not to provide, my lord, the roadblocks and umbrellas to people to hide. 17A is not a provision to hide. 17A or 19, my lord, are not provisions to hide. 17A is only, my lord, an exception in favor of an honest officer who is otherwise scared to take a decision. That is the object of 17A. 17A, my lord, has to be read in the context that it occurs, my lord, in, my lord, a attempt by Parliament to root out corruption. You can't forget, my lord, that the idea is to root out corruption. What are the basic facts leading to this case? I will show from the counter. Therefore, in that light, your lordship will, my lord, interpret 17A. If it applies, according to me, it has no application, because it is post June 2018, and our my lord, facts are prior to 2018. So, and my lord, your lordships asked a very important question: when will this be decided if there is a dispute? It's a very important question. As I said, my lord, I prefaced it. If there is no dispute, somebody can decide it. But if there is a dispute that it is not, my lord, in discharge of either official duty or public duty or, my lord, for this, that, or the other, it's only the judge who will decide. Somebody will decide finally. So, my lord, if it has commenced, in other words, if it has commenced, my lord, without this, where it applies, it doesn't apply in our case, but if it applies and we have commenced it, somebody can protest, but it is for the judge to decide, and he will then take, my lord, evidence in this. That, my lord, is the legal position. In that light, my lord, see now 2 judgments, my lord, which I want to give to you, and that it has to be construed in the context of rooting out corruption. That's very, very important. No. Now, my lord, kindly have a look at this compilation. Yeah. My lord, 2 judgments I wish to say, to show to your lordship. Kindly, my lord, turn to page 75 of the paper book, this judgment compilation. 2019 SCC 87.
This is on applicability of 17A.
That my lord, it will be decided at the trial.
For
I will give an applicability also.
no, why are you? I mean, what is the proposition?
The proposition is, my lord, if this dispute arises of recommendation in discharge of public duty, who will decide and when? The answer is at the trial. Oh, sorry. Sorry, my lord, I mistaken. My lord, kindly allow me. My lord, this judgment is on the package point. Sorry, my lord, I made a mistake. Kindly, my lord, correct it. This judgment is on the package point, namely.
I'm sorry, my learned friend will go to lunch. May I be excused for 15
Yes, of course. Yes, maybe little later. So, my lord, this is for the proposition on the package point that facts or offences relatable at a particular time will be tried by the punishments relatable at that time, the package point. On that, my lord, your lordship is done. turn straight, my lord, to this judgment which I have mentioned, which is, my lord, at page 75. Kindly note it is on the package point. Namely, offences prior to 2018 will be governed by the pre-amendment PC Act. Kindly turn straight, my lord, to para 36 and 37 at page 94 of the paper. The High Court, my lords have it. Justice Trivedi has it not. Para 36. The High Court has rightly held that no ground is made out for quashing of proceeding for the reason that the investigating agent instantly waited till the retirement of the officer. The question as to whether sanction is necessary to prosecute the retired officer is a question which can be examined during the course of trial as held by this court in so and so. In fact, in a written judgment, this court held that the investigation was not conducted by a police officer of the requisite rank required by 17. You know, we are not concerned with 17. The lapse will only be a regularity, etc. Now 37. My lords have it, no?
Yes.
Para 37. Mr. Guru KK further refers to a single bench of the High Court to contend that the amended provisions as amended, direct question, will be applicable as the amending act came into force before the filing of the charge sheet. Direct question, madam. Namely, that the amending act will be applicable before the filing of charge sheet, which means that the offences are prior to 18, but charge sheet will be after 18. So he said apply 18. Direct question, but very important. In the aforesaid case, the trial court, we do not find any merit in the argument. In the aforesaid case, the trial court applied the amended provisions which came into force and acquitted. The High Court found that the order of the trial court to apply the amended provisions not justified and remanded the matter back, observing that the offences were committed prior to the amendment being carried out. In the present case, FIR was registered in 11, much before the act was amended. Whether any offence was committed or not has to be examined in the light of provisions as it existed prior to the amendment carried out. The only difference is that in this case, FIR itself was old. In my case, FIR is new, but the events are old. That's the only difference. But this will apply with full facts. This proposition will apply with full facts, notwithstanding that mine is today, my FIR is later. Because the argument here was, I am being tried under 2011. Charge sheet is yet to be filed in the course of trial, and the amendment has happened. The court said nothing doing. All issues relating to prior amendment will apply prior amendment. So this is a direct case, number one. And as I said, 17A is not meant to be an umbrella for those who are corrupt. It is meant, for only those who are honest, and they should fearlessly take a decision. But it is not meant for corruption. Now, for the second proposition, which is
proceedings on the stage when
Not on the.
So, but the point
No, my lord.
here is
yes.
whether any offence has been committed or not has to be examined in the light of the provisions of the statute as it existed. So,
As it existed means the unamended ones.
on commission of offence, there is no doubt of applying this principle.
Correct.
But a protective mechanism
Yeah.
against an accused
Correct.
who is implicated.
I'm very grateful. Now. The answer respectfully would be, if, the law as on the date of the offence has to be applied, on that day 17A wasn't there. If in 2011, 12, 13, somebody commits an offence and he is to be tried according to that law, this 18 came 5 or 7 years later. How can this be parachuted into that? That's the point. Therefore, you can't parachute 17 back into time. They are wanting to parachute 17A back into time. That is not possible. 17A cannot be parachuted. And 17A, if it is born in 2018, how can 17A, unless the legislature clearly specifies, cannot apply to an event of 2015? It's as simple as that. Nature can say what my lord is saying. That notwithstanding the offence was earlier, we have brought in 17A, but that will make it incongruous. Trial is proceeding. Let's see how incongruous it will be. Trial is proceeding, and today 17A comes. 17A is right at the inception. How will it be relevant? How can you apply 17A midway in a trial? You can't. 17A cannot be applied midway in a given case like this, where Mr. Guru Kishan Kumar argued, trial is going on. He says 17A is coming. So what will happen? Can't go back to square A when 17A was not born. Now, the second judgment which I was showing was,
The question whether it
yes,
is.
yes. Thus, now, a very important case I am showing, that recommendations in the discharge of official functions is a question of fact and can only be decided in a trial. That's a query Justice Trivedi rightly asked. That is answered, my lord, at page 264.
Oh.
64 of
Right. Now, my lord, 264, yes.
64 of what?
Of this compilation, which I'm sorry. This compilation judgments.
There is no-
Dr. Mansoori. Yes. Dr. Mansoori, this was a case, my lord, of lack of sanction under 197.
Not listed in the
No,
Mansoori, my lord.
index.
inside.
Sorry. My lord, in index, your lordship will get, my lord, Mansoori.
Okay, there is another index, sorry.
My lord, page 18, my lord. Yeah, page 18.
It is there.
See, serial number 18, my lord,
Yes.
is Mansoori. Mansoori, my lord, is at page 264. Mansoori was a case, my lord, where he was sanctioned under 197. But the finding, my lord, when will you decide? And if I may say so, my lord, 197 is absolute. My case is better because my case is recommendations made or decisions taken in the discharge of official duty. All this has to be tried. But my lord, in 19 itself, your lordship will turn, my lord, straight to the last page of the judgment, page 268, para 15, 268 of the compilation. Look at this, my lord. And it's a case of 19. 19 is a better case because it doesn't have, my lord, it doesn't have all this. See, my lord, 14 actually, para 14 at 267 bottom. The aforesaid judgment of the High Court become final on the basis of material record. The High Court has held that in the facts of a case, para 14 my lord, at 267 bottom. The aforesaid judgment of the High Court has become final on the basis of material the High Court has held. The facts of the case be premature to hold that 197 is a bar to prosecution. The observation holds good. Going by the assertion of the complaint filed by the appellant, prima facie it appears that without any authority, first respondent along with other police personnel entered the house of the appellant and committed offences. Looking to the nature of allegation complaint, at this stage it is impossible to conclude that the acts were committed by her while acting or purporting to act in discharge of official duty. Therefore, at this stage, we cannot conclude that a sanction of 197 is required. On the facts of the case, the final view can be taken only after evidence is recorded, and the High Court could not have caused it. And that's 197. I am better because my section uses all the phrases. Recommendations made, decisions taken by a public servant in the discharge of official duty. So, firstly, what was his official duty? What is the recommendation? What is the decision? All this will have to be seen, my lord, from the evidence which is laid. It can't be, my lord, argued orally.
Mr. Wadgi, 197 has been considerably diluted
Yeah. No.
over the years.
Right.
Judgment.
Right. And it has been diluted like this. My lord is right. Now, my lord, apply these words. In this case, it was found that they entered the house of the appellant and committed offences. They said 197 is the bar. The Supreme Court said, sorry, even a prima facie look can never lead to a situation that you can have an official duty of discharge without barging into somebody's house and bashing them up. And therefore, no 197. Now, I say, I'm now going to show you a judgment that no question, my lord, of this kind of sanction can ever arise where there is an allegation, my lord, of misappropriation of public funds. Mine is a case of misappropriation of public funds. And therefore, my lord, there can be no umbrella of protection, whether 197, whether 17, in the facts of such a case, unless it is first tried and found by the court. And the courts have said, your lordships have said, that there can never be protection on this kind of argument of, my lord, public office or decisions, if, my lord, it's a case of misappropriation, because that can never be, even prima facie, a part of somebody's official duty. That's how it works. Otherwise, my lord, this will become a panacea.
Mr. Rogi, can you answer one thing?
My lord.
Can an FIR be registered for an offence which is no longer an offence under the new act? Though they have not argued this.
Yes, of course.
Time offense was committed.
Question is at the time, yes, ma'am.
In
Unless there is a limitation.
21, there is no offence.
No. Again, we are back, yes, ma'am.
13(1),
I appreciate your lordship.
CND.
Yes, ma'am. It's an important query. The answer, my respectful submission will be, my lord. If, my lord, suppose there is a limitation, see, some sections have limitations. Under the CRPC, there is a limitation for some petty offense. Unless it's a case of limitation, an offense committed at a particular time is not wiped out, even when the sections are repeated thereafter. Unless,
Can you substantiate that?
yes, general clauses that will say,
Because-
I substantiate.
Because you are right, 17A would apply to the offences under the act at the relevant time.
My lord,
So
which
now-
is the second package.
So now, as per the amendment.
Yes.
But according to you, the offence was committed under 13(1) CD,
CND
which were the offences at the relevant
and
time.
IPC, my lord.
And IPC also.
Yes.
At present, IPC we are not taking because.
But, my lord, it is important to note that it is an amalgam of both.
That according to you, 17A would not apply.
Correct, correct,
So
absolutely correct.
can FIR be registered?
There is no bar, my lord.
for
The law must provide a bar.
Which is no longer an offence
Mean-
under the new act.
So it is
Under the
irrelevant.
amended act.
Yes, correct. My respectful answer will be, there is no limitation for lodging an FIR in respect of an offence which may have been committed 10 years ago. But it will only be in regard to what was then prevailing. There is no bar, my lord.
Please substantiate that.
I'll see, my lord, let's say. There is no bar as I see, my lord, in any law, in, my lord, registering an FIR, in registering an FIR in relation to an offence which may have occurred when the law was prevalent, notwithstanding, my lord, that it would, notwithstanding that it has since been deleted. Lord, see, for example, what comes to mind, Article 20, my lord, of the Constitution. Just have a look at it. Article 20. Coupled with the fact, my lord, that there is no bar for registration of an FIR. FIRs can be registered even after 10 years, 20 years.
For the offence,
Committed earlier, when it was prevalent. My lord, see 21. Article 20, subclause 1. Yeah. My lord, with this, your lordship will see 468, which is the limitation point. See, my lord, Article 20, protection. No person shall be convicted of any offence except for violation of the law in force at the time of commission of the act charged as an offence, nor be subjected, see the second part, nor be subjected to a penalty greater than what might have been inflicted under the law in force at the time of commission. So, my lord, if an offence yesterday was punishable by 1 month, and today law is amended and 1 month becomes 1 year.
entire criminal machinery is set into motion with the registration of FIR.
Yes, correct.
So one conviction, there could be a possibility that in between the period from registration of FIR till conviction, or trial is ended, the law might have changed, and therefore this 468.
Correct.
Here, date, because the very
Registration.
registration is the first step
Correct.
for triggering the,
So let us say, let me answer it another way. Suppose, my lord, an offence is committed at a particular time when it is an offence. It is only after 5 years or 10 years it is found that somebody has committed that offence. The law says you will book him. You will book him today onwards because you come to know today. Otherwise, my lord, the law will have to say. It's an important query which the lordship raised. Otherwise, the law will have to say that you, once you have found today, but in respect of an offence which occurred earlier, you will be debarred from registering or even looking at it. Some law will have to say, my lord, that there is a debarring. So there is no concept of that except, my lord, where there is limitation. See, for example, my lord, 460.
in such cases, the FIR might have been registered and the person might have been caught later on, and but the registration.
Not suppose it's not found. Suppose the offence is found later. Suppose, my lord, somebody kind of disappears. Absconded, somebody disappears. You don't know where it is. After 10 years, it is found that somebody has committed a murder, my lord, he'll have to be booked. There is no issue of that. Kindly take it, my lord, there is no issue at all of that. Otherwise, it will, unless the law provides. For example, my lord, 468 of the CRPC is a bar to cognizance where limitation is provided. You may register FIR, you may do whatever, but there is a bar to cognizance under 468. Where, my lord, the lordship may see 460.
Even during the
Yes. See, my lord, 468. Bar to taking cognizance after lapse of limitation. So there are some, my lord, petty offences where the limitation is provided. For example, my lord, only fine. So the laws, my lord, wisdom is that for smaller things, don't go on after, my lord, 5 years, 3 years, 10 years, whatever. That's the limitation. That's now, my lord, see section 6 of the General Clauses Act. Some answer is given, my lord. Section 6 of the General Clauses Act. General Clauses Act. In fact, my lord, your lordship may see in 468, if it is beyond 3 years, there is no limitation. My lord will note that. So if it is beyond 3 years, there is no limitation. If it is beyond offences, beyond 3 years of punishment, there is no limitation, which means, my lord, there will have to be an FIR at some stage, investigation and charge sheet, and then 468. 468C, 2C will show, my lord, that more than 3 years punishable offence, there is no limitation. So for the offence to be investigated, there will have to be an FIR, then a charge sheet, and then, my lord, cognizance, etc. will have to happen. Therefore, the FIR can be registered in a case where the bar of limitation does not apply, and that investigation will proceed, resulting in a trial. Now, my lord, see section 6 of the specific relief. This is also an answer. See, my lord, section 6 of the General Clauses Act. My lord said. Now, in our case, my lord, 13 months C and D have been repealed, as my lords were just pleased to observe. Now, my lord, look at 6, my lord, in the light of this. Where this act, effect of repeal. So C and D have been repealed, gone. Where this act or any act made after commencement, these are repeals any enactment made or hereafter to be made, then unless a different intention appears, this is very important. Unless a different intention appears in the Parliament, the repeal shall not. Now see, my lord, E. The repeal shall not affect, that is C and D having gone, will not affect any investigation which will be post, my lord, FIR in the query posed by Her Ladyship Justice Trivedi, will not affect any investigation, legal proceeding or remedy in respect of any right, privilege, obligation, liability, penalty, and any such investigation, legal proceeding, remedy may be instituted, continued or enforced And any such penalties also may be imposed as if the repeal had not been passed. So preserve package A or preserve package 1 as it is.
This does not include inquiry. Investigation starts with the registration of FIR.
That's true, but my lord, your lordship's query was, could you register an FIR at all?
So this will not apply.
Yes, okay, this is a repeal. Now, my lord, one more judgment I wanted to show on what is the position, the views taken by the court.
Just 1 minute.
Your lordship may see, my lord, whether a case of misappropriation of public funds can ever be, my lord, a question to provide protection. No question of protection will arise. Your lordship may see, my lord, page 148 of this compilation, Shambhunath's case. This was the case of 197. But just see, my lord, what the fact was.
It was permitted.
Sorry?
Line of Shambhunath,
Yes,
they were permitted. 197 could be taken later on,
yes.
not abused.
No,
These are the.
But some of the words are very good. Just have
and
one
the-
paragraph.
Starts with Dilip something.
Correct. But just see, my lord, one paragraph here, page 148 of this paper book. Kindly turn. See, my lord, 149. For 148, the judgment starts. The High Court, my lord, said that 197 is necessary. It held in favor of the employee. Matter came to this.
ये बात ऐसे क्रम में कि बहुत साल के बाद कोई कॉग्निजन नहीं है.
Mr. Rohatgi, how long would you take? Can you give us? We don't want to cut short.
Yeah.
But.
Maximum, my lord, an hour, maximum.
uh,
Maybe even less.
Spill over.
We'll adjourn
What being
an hour.
there?
Today,
We have the regular board.
Oh.
Make this change.
Tomorrow, your lordship's bench is not there. There are 3 judge bench tomorrow.
but may I just say this?
No.
Accommodate today.
With what we are thinking, Friday at
Whenever, my lord, your lordship's convenience.
Friday at 2 p.m. So in the first half, we can finish.
Can I seek indulgence subject to your lordship's convenience? But
My lord, kindly don't keep it in the first half, my lord.
No, we are not.
is it
We'll
possible?
keep it after 2.
Correct.
Possible at all to accommodate today post lunch?
No.
But if he concludes, we'll also finish off Lord today.
Too many.
And
This is
I'm
a
just saying, no,
miscellaneous.
no,
I know, my lord, it holds up the whole board.
we would have concluded the matter today. Put in half an hour.
No, then what we can do, you can come back at 2.
Yes.
We'll take up, run through the list
Yes.
and urgent matters we can take and then
Whatever.
we can carry on, and in any event, you will have to.
But we'll take very short run, half an hour, depending on what he says.
My lord, may I take half an hour instead of 1 hour? Half an hour at 2 o'clock and be done with it.
Then,
Because I have also not held up in several other cases.
and not, we'll also.
Requested to complete the
Also conclude
part.
by three.
Better Friday.
Not-
Friday better at.
Not
Friday, yes,
Not
Friday.
when we can, if your lordship comes out, we'll conclude, I think, between both of us by 3. That's
My
what, if he
my
takes.
friends
half
are
an hour-
insisting.
Not
My
if-
friends are insisting they don't do it in half an hour.
All right, let him do it, Lord, we'll conclude today, Lord, your lordship.
No,
will-
then,
Unless Mr. Rohatgi concludes how we.
Lord,
Lord,
it
he-
will be
he's saying
difficult.
1 hour. He's saying an hour.
I have not a
We have-
some advisors have.
Couple of days.
So your lordship will take it on Friday at 2 o'clock. That's
Not,
fine.
it may just conclude the matter, that's all.
No, no, please, let's do it on Friday.
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 at
You have taken 1.5 days, let me also have some respite and answer Justice Trivedi's queries, I'll look at some.
శుక్రవారానికి వాయిదా వేస్తాం అంటున్నారు
I
జడ్జి.
have to answer those queries.
I must.
They're queries of the court.
Reason I was requesting was
वो भी इसमें आ गया.
if my lord may consider, but if not Friday, would Thursday be convenient, because I think Mr. Salvi may have some.
సూత్రాగారం ఇప్పుడు కంప్లీట్
I'll
చేసేద్దాం
just check, but if
అంటున్నారు.
you want, may I just come back at 2 o'clock in form?
मैं भी मंडे फ्राइडे.
Or Monday.
I'm saying,
Monday.
Monday should be.
If Monday
I'm
afternoon.
saying not,
No, no, Thursday we have final hearing matter.
There are
And the bench is not there.
different benches.
I'll leave it to your lordship, but if it's today's convenient, it'll be.
No,
గురువారం
no, today
గురువారానికి
is
ఏమో
not court
లోత్రా గారు
meeting, we have
అడుగుతున్నారు.
too many things going on. Friday or Monday, whatever is the lordship.
వాడమ్మా వాడైతే ప్రభుత్వం తరపున లాయర్ అయితే ఏకంగా మండే అడుగుతున్నాడు.
Let.
Let them finish today, bro.
Thursday
Why
final
should we
hearing
do
అంటున్నాడు.
Sunday then? If it is to go to Friday or Monday, I'll finish it on that day.
If Mr. Salve has difficulty, we'll post
Lordship, I
it.
have
Not
it on
Friday,
Monday, bro.
no, Lord, then he'll come on VC, Lord. May I just say this, Lord? Let me just come back at 2 o'clock, because he just stepped out of why don't you just call? Wait, just give me half a minute, I'll just check with him. I think he just stepped out to another matter.
What is there? There were 3 people doing the petition originally. You
I
can do the
have
rejoinder.
no problem doing.
What is the problem? You can do rejoinder on the VC.
I'll tell you what you at 2 p.m.
Okay.
I'll tell you at 2 p.m. I'll tell you at 2.
Grateful, very grateful. Obliged.
జడ్జి గారు వెళ్ళిపోతున్నారు. రెండింటికి చెప్తాం అన్నారు. ఎప్పుడు వాయిదా వేసేది ఏంటి రెండింటికి చెప్తాం అన్నారు. అది ఫ్రెండ్స్ పరిస్థితి. 2 గంటల వరకు అయితే మనం ఎదురు చూడాల్సి ఉంటుంది. మరి వాళ్ళ వాదనలు పూర్తి చేస్తారా, లేదంటే సోమవారమా, లేదంటే గురువారమా, శుక్రవారం అనేది మధ్యాహ్నం 2 గంటలకి తెలుస్తుంది. అప్పుడు వరకు ఒకవేళ